regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. In fact, you're going to be keeping me company today. We talked with John Comerford, NRA ILA Executive Director, yesterday, and just a couple of hours after we conducted that interview, the 10th Circuit Court of Appeals came out with a decision basically reversing a district court's refusal to grant an injunction against New Mexico's 7-day waiting period. The 10th Circuit panel saying, this is a case, by the way, that was brought by the NRA, and the 10th Circuit panel saying, no, the plaintiffs are likely to prevail on the merits here. This 7-day waiting period does not comport with the national tradition of gun ownership. The scope of the injunctive relief that will be applied remains to be seen, but we're going to talk with John Comerford about that decision and hopefully about that lawsuit that he was hinting at next Tuesday here on Bearing Arms, Cam and Company. Also hoping to talk with Rick Travis from the California Rifle and Pistol Association on the program tomorrow about AB 1127. That is the Glock ban bill in California. It had a hearing earlier this week and was placed on the suspense file. But that ordinarily that would be good news, right? That means that at least for the moment, there are no plans to bring this to the floor of the Senate. Given that this is California, however, given the priority that this bill is for anti-gunners, I'm not convinced that gun owners can breathe easy right now. So hopefully we'll get an update from Rick on tomorrow's Bearing Arms, Cam and Company. But on today's program, I want to talk about, and I wrote about this as my first story of Bearing Arms today, but I want to talk about this as well because this is just so interesting to me. The Washington Post reporting on Tuesday night, Pirro's office won't pursue gun charges over carrying rifles and shotguns. Mario the Rooster is very happy to hear that news. D.C.'s top prosecutor said her office would continue charging violent crimes and firearms trafficking that involve those weapons. So, Jeanine Pirro, the U.S. attorney for Washington, D.C., apparently has been instructed, I guess based on a memo from the Department of Justice written with the help or maybe exclusively by Solicitor General D. John Sauer, not to seek felony charges against people who are carrying rifles or shotguns in the nation's capital, regardless of the strength of the evidence. That, according to Jeanine Pirro and the email reviewed by the Washington Post. Post goes on to say that Pirro, an ally of Trump who was confirmed as DOJ's top federal prosecutor this month, said her office would continue charging crimes of violence or firearms trafficking that involve shotguns or rifles. No indication that D.C. prosecutors plan on stopping charging people found to be illegally possessing handguns, which account for the bulk of the firearms offenses in the district. In a statement to the Post, Pirro said on Tuesday night that the D.C.'s blanket prohibition on carrying shotguns or rifles is, quote, clearly a violation of the Supreme Court's holdings in both the District of Columbia versus Heller case, which established that, yes, the Second Amendment does protect an individual right to keep bear arms, and Bruin, which established that May issue carry laws violate the Constitution. The Post goes on to say the Supreme Court held in the first case, blah, 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 blah. Yeah, I don't need to relitigate that. So this is interesting because the DOJ apparently believes that the district's ban on carrying rifles or shotguns violates the Second Amendment. That's good, right? But from a practical standpoint, is this really going to matter that much? Most people aren't openly carrying rifles or shotguns in the District of Columbia, and I don't expect that's going to change now that Pirro says that felony prosecutions won't take place. So why not? I mean, this is supposedly because this is consistent with the Heller and Bruin decisions, right? So would it not also be consistent with the Heller and Bruin decisions to, at the very least, say that individuals who possess a valid carry permit from one of the 50 states will also not face felony charges for carrying a handgun in Washington, D.C.? I mean, that to me is also consistent with what the Supreme Court said in Heller and Bruin. Now, it is true that D.C. has a blanket prohibition on carrying rifles or shotguns. There is not a blanket prohibition on carrying a firearm in general or carrying a handgun specifically. In order to legally carry a handgun in Washington, D.C., though, you must possess a valid D.C. permit. Non-residents can apply for those D.C. permits, but it's not particularly easy unless you live nearby. I mean, even in Central Virginia, which is 3 hours south of D.C., I don't know that there's a firearms instructor near me who teaches the D.C. carry course so that I could apply for a D.C. carry permit after taking the required training. I'd probably have to drive up to the D.C. suburbs or into Maryland. By the way, you can't obtain that training in Washington, D.C. because there are no publicly accessible ranges in Washington, D.C., which is a problem in and of itself, that the district has licensing laws that cannot be met without traveling outside of the district. That, to me, should make the district's licensing law null and void, but that's a topic for another story altogether. Again, I have no complaints about this policy. I don't think it's a bad move. I'm just kind of left scratching my head as to why this was the move and not something that would benefit far more, certainly non-residents, and maybe DC residents as well. The Post went on to say that regarding the new policy, Pirro added, nothing in this memo from the Department of Justice and the Office of Solicitor General precludes the U.S. Attorney's Office from charging a felon with possession of a firearm, which includes a rifle, shotgun, and attendant large-capacity magazine, pursuant to D.C. Code 22-4503. What it does preclude is a separate charge of possession of a registered rifle or shotgun. So that raises some other questions. First, again, if we're talking about consistency with what the Supreme Court has said in Heller and Bruin, why would the U.S. Attorney's Office be prosecuting anybody for possessing a quote-unquote large-capacity magazine? Now, again, if you're a felon in possession, you're not allowed to possess a firearm or ammunition. But I don't think federal law precludes you from possessing a magazine. D.C. statute might, but I don't think federal law does. Although, again, it's an open question, right? Because if magazines are arms and you're not allowed to possess an arm as a convicted felon, then maybe magazines would be covered. Regardless, I do have questions about why the U.S. Attorney's Office would be enforcing laws against quote-unquote large-capacity magazines. If, again, we're talking about consistency with Heller and Bruin, because the Supreme Court has said in Heller and reiterated in Bruin, as well as in the Catano per curiam opinion that came down in 2016, that arms that were not in existence in 1791 are protected by the Second Amendment. Doesn't have to be a musket, right, or a cap and ball pistol, or the drawn-to-air rifle. And that prima facie, arms that, prima facie, actually all bearable arms are protected by the Second Amendment, but specifically arms that are in common use for lawful purposes, including, but not limited to, self-defense, are protected by the Second Amendment. So, we talked about this with John yesterday, actually talking about the Duncan case. The Ninth Circuit says that magazines aren't arms, so they're not protected by the Second Amendment at all. So California could pass a ban on all detachable magazines and wouldn't violate the Second Amendment, according to the Ninth Circuit Court of Appeals, right? The counter-argument to that is that, no, magazines are an essential component of semi-automatic firearms, and so to ban magazines based on their capacity does represent an historical law, right? Because we didn't have any laws regulating the capacity or limiting the capacity of firearms, at least not magazine-based laws, until the 1990s, maybe late 80s. Right. I think there was actually one local law in the District of Columbia passed in the 1920s, but that's not evidence of a longstanding national tradition. Right. So if arms do include magazines, and they do fall under the Second Amendment protections, which is what Second Amendment advocates are arguing, Then those quote-unquote large capacity magazines that Pirro says they might continue to prosecute at least felons for possessing, that would seem to be contrary to, at least somewhat contrary to what the Supreme Court has said. It also raises the question about, okay, if felons can't possess those things, what about the average everyday citizen caught in possession of a large capacity magazine in D.C.? Will they be prosecuted? There are also some specific questions, right? So like D.C. banned so-called assault weapons. They've got their own definition. Pirro says nobody's going to get felony charges for carrying a rifle or shotgun as long registered rifle or shotgun, right? That's another thing we're going to talk about. So if it's a registered rifle or shotgun, then presumably that would mean that somebody bringing their AR-15 over from Virginia and openly carrying in Washington, D.C. could in fact still be arrested and charged with a felony. In fact, multiple crimes. They could be arrested and charged with violating D.C.'s assault weapon ban, right? They could also be arrested and charged with a felony for carrying an unregistered rifle or shotgun. D.C. has local gun registry. I guess if you're traveling to the District of Columbia, you could theoretically register your guns with the Metropolitan Police Department, but I would think the vast majority of people traveling to D.C. would not do so. In fact, I'm guessing the vast majority of people traveling to Washington, D.C. leave their guns behind because they don't want to run afoul of the district's draconian gun laws. So if that's changing, if the enforcement of these laws are changing, it is incumbent on the DOJ to very specifically lay out what the policy is going to be going forward. And there are a lot of unanswered questions here even after U.S. Attorney Pirro's statement here. Again, does this apply only to D.C. residents who have registered rifles or shotguns? Does this apply to people who can legally possess a rifle or shotgun but cannot legally possess a quote-unquote a large capacity magazine under D.C. law? And again, why does this apply to the open carry of rifles and shotguns, but not the concealed carry of handguns, particularly by those individuals who possess a valid carry permit from one of the 50 states, permits that are not recognized by the District of Columbia? Now, it could be that we're going to get more guidance coming out of DOJ and the Solicitor General's office that would actually expand on those protections and instruct the U.S. Attorney's Office not to charge people with felony offenses as long as they can produce a valid carry license from one of the 50 states. Again, it would raise another question about what about those individuals who live in states where a license to carry is not required? As long as they can lawfully possess a firearm, they can legally carry it. Should they be able to also do so in Washington, D.C.? Again, I'm not complaining about this policy change. But it does leave me scratching my head, and it does open the door to a lot of very reasonable questions about why additional steps have not been taken, and again, just about the scope of the enforcement of the law going forward. And I would hate to see somebody, again, decide to test this out, travel from Virginia with their AR-15, decide to walk around one of the non-sensitive places in Washington, D.C., openly carrying, only to find out that, they are still prosecuting people for having an unregistered rifle. They are still prosecuting people for having a large capacity magazine. They are still prosecuting people for having a so-called assault weapon in Washington, D.C. We need clarification on these things. And we need it ASAP, because if the policy has changed, people need to know the details of that new policy. And again, I am hopeful that this is just the start of a move to, if not bring D.C.'s gun laws in line with the Second Amendment, to at least bring the prosecutorial standards in Washington, D.C., with the U.S. Attorney's Office in line with the Second Amendment. This would be a good first step, but still a long way to go. And honestly, just being blunt here, a better first step would have been to address concealed carrying of handguns, because, again, that is how the vast majority of people choose to protect themselves out in public. Not with a rifle or shotgun, but with a pistol. So if you are hoping to have a meaningful impact and a positive impact on people's ability to protect themselves in Washington, D.C., that would have been the place to start. Maybe the outright ban on carrying rifles or shotguns is more low-hanging fruit. But again, I think it's fruit that most people don't want to eat. What would that be? An unripe pawpaw or something like that. Anyway, we will see what happens here with the DOJ policy going forward. I'm going to be reaching out to the U.S. Attorney's Office to see if we can get any more specificity about the scope of these policies, and hopefully we'll be able to report some details to you here at Bearing Arms and Bearing Arms Cam and Company in the very near future. Right now, though, let's turn our attention to today's armed citizen story, our good deed of the day, and our recidivist report. We will start there with a case out of Massachusetts. Fall River police arrest man with lengthy criminal history twice in 2 days. Listen, I don't even normally show mugshots, much less comment on them, because, I mean, look at me. People in glass houses shouldn't throw stones, right? It's not like I'm Brad Pitt here. But I will say that this guy looks like a mashup between like Post Malone and Adam Duritz from Counting Crows, and the facial tattoos just not a good look, especially the facial. I'm not a fan of facial tattoos to begin with, but if you're balding, man, shave it off. That's just a terrible look. As is being arrested twice in 2 days, by the way. That's also not a good look. And remember, Massachusetts, they seem very interested in going after lawful gun owners. But individuals with lengthy criminal history, I mean, sure, they might get arrested, but they're spit back out on the streets very quickly, right? August 18th and 19th, that's when 34-year-old Vincent Valoy was arrested by Fall River police. On the morning of August 18th, investigators conducted a investigation over a report of trespassing and found multiple people behind these businesses in Falls River, including the Valoy, who allegedly led officers on a foot pursuit. They were able to arrest him. They charged him with trespassing. Again, a pretty minor offense here. But they added that Valoy also had a lengthy criminal history and had several outstanding warrants. So you would think that the outstanding warrants would at least have kept Valoy behind bars. No, because Tuesday afternoon, officers responded to another area in the city on reports of a man suffering a stab wound to his leg. That individual turned out to be Valoy, who they discovered bleeding from his leg, quote, acting belligerent and refusing repeated commands to stop and show his hands. Despite giving multiple commands and warnings for safety, Fall River police said Valoy, quote, advanced towards officers in an aggressive manner, at one point demanding to be shot. After police unsuccessfully attempted to stop Valoy using their tasers, officers were able to bring the defendant to the ground and take him into custody. When they put him in handcuffs, they allegedly found Valoy in possession of about 1 gram of powdered cocaine and almost a gram of crack cocaine. Valoy declined medical treatment for the stab wound to his leg. He was taken to the Fall River Police Department for booking, and I imagine he's back out on the streets now. Because that's what Massachusetts does with people with lengthy criminal histories. They allow that lengthy criminal history to grow ever longer. Even if you got outstanding warrants, you're not going to be spending a lot of time behind bars. So I hope that Vincent Valoy can turn his life around and maybe get a haircut. But I imagine that he'll be showing up in the police blotter there in Fall River, Massachusetts at some point in the not-too-distant future. Sorry about that, by the way. I didn't mean to leave his mugshot up for the entirety of that story. All right, on to today's armed citizen story. We don't have a lot of information about this one. Phillips County, Arkansas, a fatal shooting in Phillips County ruled self-defense. That's the good news here. Shooting happened back in July. Unfortunately, again, not a lot of details released by the Arkansas State Police. The Northwest Arkansas Democrat-Gazette reports that a man from Poplar Grove, Arkansas, will not face charges in connection with this shooting in July that left 1 person dead and another injured. First Judicial District Prosecuting Attorney Todd Murray concluded that 41-year-old Deckerick Farr was acting in self-defense when he shot and killed 38-year-old William Henderson back on the 5th of July. It happened about 2:15 in the morning. Sounds like in a pretty rural area there in Phillips County. Henderson was pronounced dead at the Helena Regional Medical Center. Another man, a 47-year-old who was not identified in a police news release, was taken to an area hospital, listed in stable condition following the incident. Maybe he was a bystander who was accidentally shot. It seems odd that the police would not release any details about that individual if he was facing charges. So apparently he's not. Maybe he was shot and injured by Henderson. We don't know because, again, we don't have a lot of details here. But Farr was initially arrested on a charge of first-degree murder. Phillips County Sheriff's Office requested an investigation by the state police. They submitted their findings to Murray's office for review. And then again, Murray concluded that Farr was acting in self-defense when he shot and killed William Henderson. Wish we knew more about the circumstances. Wish we knew more about the third individual there. But that's what we've got. And hopefully more details will be forthcoming. Finally today, our good deed of the day. In the right place, at the right time, willing and able to do the right thing. A scary situation out of New Hampshire. This from the Laconia Daily Sun, which reports a 74-year-old kayaker is lucky to be alive thanks to the quick actions of a good Samaritan who helped him after his kayak had flipped over and he was unable to get himself upright. This was back on August 18th, just a couple days ago, about 4:20 in the afternoon at Franklin Falls. First responders with the Franklin Fire Department dispatched to the area for reports of a person who had flipped a kayak and failed to reemerge from the water. The person who called 911 assumed that the kayaker was missing, but as the paper says, in reality, they were trapped upside down in their kayak for between 30 seconds to a minute before a good Samaritan from Colorado decided to just take a quick dip while he was passing through. Just wanted to get into the water to cool himself off, and then noticed this kayak upside down traveling down the river. Deputy Fire Chief David Hall said a civilian out of state who was enjoying the river and doing some swimming on their own saw him at one point through his travels down the river. He caught up to him and turned him over. So the gentleman was discolored. He was not doing well. By the time first responders got there, the kayaker was at least upright, not necessarily okay. He had traveled about 120 yards down the Winnipesaukee River underwater. They were able to relocate the kayak closer to shore, removed the man who was taken to Concord Hospital, Franklin, with non-life-threatening injuries. The fire chief says this Good Samaritan literally driving through and stopped to enjoy the water feature. They were river folks. They understood the water. So, I mean, again, you talk about being in the right place at the right time, willing and able to do the right thing. If this individual had just decided, don't have time to stop and do some swimming, if he had been looking in a different direction, if this had happened 2 minutes earlier, it might have been too late for that 74-year-old. So an amazing set of circumstances that led that Coloradan to save the life of a 74-year-old man. Wish we knew the name of that Good Samaritan. We don't, unfortunately, but whoever you are, thank you for your very, very good deed. All right, that's going to do it for this edition of Bearing Arms Cam & Company. I want to thank you for being a part of the program. Don't go testing this new policy in D.C. today, not until we get more information about the scope and parameters of what it means that no felony charges for openly carrying a rifle or shotgun if it's registered in the district. Again, a lot of caveats, a lot of fine print. I don't want to see anybody getting felony charges. So we'll hopefully get some more information and bring that to you on tomorrow's program and at bearingarms.com. And again, we'll be back tomorrow with the latest Second Amendment news and information from all across the nation. Be sure to check out bearingarms.com today, that we're keeping you up to date on everything that's going on with your right to keep and bear arms, whether it is litigation, whether it is legislation. It is all right there for you. And again, we really appreciate you being a part of the program. I'm not sure what is going on with outro music, but I can do it. Maybe you can. Yeah, I guess you can. All right, I don't know why I can't. Anyway, have a great rest of your Hump Day Wednesday. We'll see you back here tomorrow. Until then, do well, be safe, and be free.